The Anti-Money Laundering, Anti-Bribery and Anti-Corruption course, designed for South Africa. So if we're going to consider a career in organised crime, where would you have it? Government or private sector? Just to give you an idea of how many people have been fined in the last fiscal year. Now, this was in March 2015, and these figures were taken from the FICA report. In 2014-2015, the first imposed enforcement penalties on institutions in South Africa for the FIC Centre came into play. And that was 140 million rand. So you can see this is becoming a very nice way of supplementing our income tax and our tax collection, because in America last year they managed to bring in an extra $5 billion to the state coffers. So I think we can safely say that this is not going to go away. At present, in South Africa, there's 870 cases to law enforcement for investigation from the FIC Centre, and the preservation, forfeiture or confiscating of assets has been to the value of about 2.3 billion. And the preservation, forfeiture and confiscation is pretty much an international trend, which is why we have it. What are the crimes that they've managed to stop so far? Well, truck hijacking syndicate, copper theft, there's been a cannabis hydroponic lab, they've had a cross-border romance scam. That was actually quite sad. They preyed on rather desperate ladies and got them to courier high-value electronic equipment worth about 2.4 million rand. Sorry, not billion rand, million rand. They also cracked an ATM fraud that was 165,000, and of course blood diamonds, which is an ongoing thing, I think, in Africa. There's estimates of an illicit financial flows of 147 billion rand in South Africa, of which 65% of illicit financial flows arise from commercial tax evasion. So, of course, SARS is very interested in this. 5% of those come from corruption and the theft of public funds. We won't say who. Reportable and accountable institutions grew from 26,316 to 30,461. And that, of course, again was in March 2015, according to the figures. So you can see we now have a very vibrant and very sustainable FIC Centre that is starting to make a serious impact not only on the law-abiding citizens of South Africa, but also on the criminals. Let's have a look at some local and international fines in the 2014-2015 year. And these netted in America the total of $5 billion. So I think we can see this is going to be a very nice way of supplementing our revenue in countries. And South Africa has not proven to be backward in coming forward on this. In the HSBC, a £28 million sterling fine was given. And this was by the Swiss authorities. And they were given a final warning for system deficiencies and told there would be increased supervision on them. That you don't particularly like to know, because that really feels like you're sitting under the sword of Damocles. In America, JP Morgan Chase Bank entered into a 2-year deferred prosecution agreement and $2 billion in penalties for failure to alert authorities to a pyramid scheme run by one of the bank's clients for over 2 decades. And that highlights the fact that we must know where our source of income or source of wealth comes from. Standard Bank in South Africa received a 10 million rand fine for faulty record keeping. Then they got a 20 million fine for failing to comply with the suspicious transaction reports, and a further 20 million fine for cash threshold suspicious transaction reports which they didn't submit. Finally, they got a 10 million rand fine because they didn't report property associated with terrorist and related activities and were in contravention of Section 28A of the FIC Act. First Rand had a Section 29. Well, Section 29 is a failure to report suspicious and unusual transactions, and they got 25 million rand for that. And their client identification and verification was found faulty, and they got 5 million for that. They also had a directive for record keeping in contravention of sections 22 to 24 of the FIC Act because they did put in corrective measures. Nedbank, for client identification and verification, got 15 million rand, and they failed to report a section 28A or terrorist suspicious transaction report, so they got 10 million for that. Barclays, they didn't do their client identification and verification, so they also got a 10 million rand fine, which seems to have been rather common on that. Capitec Bank also received a fine for cash transactions of 5 million rand. They did not have as big a fine as everyone else, but 5 million is still quite substantial. Deutsche Bank also had a fine for client identification and verification, which we haven't put on this slide, and that was 10 million. And they also had a directive given to them for terrorist reporting. Winning Post Bookmakers in the 8th of July 2014 got a 4,000 rand fine because they didn't report cash threshold transactions. Port Tapper, which trades as Superbets, also had fines of 5 million rand, which 1 million rand was suspended for 5 years. So those were the fines that were given out this last year. And you can see they were quite substantial. What is our picture legal and internationally? So what is money laundering? Well, money laundering really is any act performed by a criminal or a third party such as an F&I, an insurance intermediary, or a bank employee, which has the effect of concealing or disguising the nature, source, location or disposition or movements of proceeds of unlawful activities. The act referred to here is not the act of commission of the original offence, but the act or transaction that has the effect of concealing or disguising the nature of the proceeds of unlawful activities, such as depositing this so that it appears to be clean money. And it does have a problem with our economy because it makes our interest and exchange rates more volatile and causes high inflation. Now, FATF, the Financial Action Task Force, says a money laundering offence has 3 core elements. That's the act of money laundering, the presence or benefit of proceeds of crime, and the knowledge or the fact that a money laundering transaction has taken place. As money laundering does not form part of the official economic statistics, it is difficult to measure precisely the extent of the problem. Governments can only make rough estimates as to the total value of illegitimate money that's circulating in our economy. In South Africa, the estimate is around 80 billion laundered annually. Money laundering is considered to be one of the biggest businesses in the world today. The Financial Intelligence Center was formed due to the Financial Intelligence Center Act, and the address is on the slide if you need to get hold of them. How do they interpret the Act? Well, they issue guidance and information products quite regularly. There's 29 that have been issued so far, and these are products that interpret the legal meaning and application of aspects of the FIC Act and associated regulations. During 2014-2015, Financial Intelligence Center issued 6 guidance products. The public compliance communication notices are issued in terms of Section 4C of the FIC Act and provide an interpretation of issues arising out of the FIC Act, while directives are issued in terms of Section 43A of the FIC Act. Only the Financial Intelligence Center is permitted to issue such interpretations and its directives. And those ones that were given this year was PCC 29, which was issued on the 18th of July 2014, which gave clarity on the application and use of Exemption 4 of the FIC Act, Directive 03, 12 September 2014, which was notification and failure to report as required by the Financial Intelligence Center, PCC 30 on the 28th of November 2014, which had customer identification and verification of casino junket agents and their underlying clients in terms of the Financial Intelligence Center Act, the revised PCC 24, which was issued on the 28th of November 2014, which was the verification requirements of South African companies and closed corporations in terms of the Financial Intelligence Act. In March 2015, they issued PCC 31, which is acceptance of funds by an accountable institution prior to the completion of the prescribed client identification and verification. And to summarize that, the answer was no, you can't. And the revised PCC 034, which was issued on the 27th of March 2015, which had supplementary information applicable to PCC 03 electronic verification systems of asylum seekers and refugee permits. The guidance notices are all very important to us, as they have a single standardized reporting definition and format across all reporting types, whether it happens to be suspicious transaction reports, client transaction reports, all of the transaction reports. GoAML is the preferred system to handle all the reporting data requirements analysis, the case management and secure communications required for its daily operational functions and requirements, and you will do. So what do we have? Well, we have the Prevention of Organised Crime Act that was created in 1998, and it's still around. It creates the money laundering offences because FICA only deals with the actual proceeds of the crime. We then have the principal money laundering offences created by POCA, which are offences related to racketeering activities, offences related to the proceeds of unlawful activities, and that includes money laundering, assisting or helping another person to benefit from the proceeds of unlawful activities, and acquiring, processing, or possessing the proceeds of unlawful activities. Now, POCTA has been put in place to create the offence of terrorism and a number of terrorist-related offences, including the terrorist financing offences. It criminalizes owning, possessing, or acquiring the property or entering into any transaction in relation to such property for the purpose of committing any terrorist-related activity. The Prevention of Organised Crime Act simply deals with crime. Now, fines of 100 million rand to 1 billion rand or imprisonment to 30 years to life are given by this act. So you don't want to fall foul. The Prevention and Combating of Corrupt Activities Act number 12 of 2004 creates a situation where in Section 22, the National Director of Public Prosecutions may, upon reasonable suspicion, institute investigations regarding the property relating to corrupt activities. And you do have a duty to report corrupt activities, and that amount is at 100,000 Rand that has been set, and anything that is over 100,000 Rand or more has to be reported. Section 35 allows the provisions of this Act to have extraterritorial jurisdiction, just like the Corruption Acts of America and Britain. It's important to note that none of these acts enjoy precedence over one another. They are all aimed at combating the money laundering, but in different ways and to different degrees. And the proceeds of unlawful activities are not restricted to the initial proceeds of the crime, but also extend to the converted form. The crime does not have to be committed in South Africa because it does not matter where the crime was committed. Client identification and verification, and record keeping, reporting, formulating and implementing internal rules, compliance officer appointment, training of your staff, and registration with the Financial Intelligence Center constitute the 7 pillars of risk-based requirements that are required in terms of our legislation. The compliance officer must be formally appointed and must have general knowledge of the overall operations of the institution, and they must interact with all areas of business to keep abreast of the changes that may require action and have access to all areas of operations to effect the corrective action. The training, on the other hand, is responsible to make sure that the training is ongoing, the manual is updated, and employees should not deal with clients if they're not trained, and this compliance officer is responsible for making sure that happens. In summary, employees are your first line of defense when it comes to money laundering. The regulations do provide for exemption from the identification and verification requirements for the different accountable institutions in respect of different products. So in the case of insurance and investment providers, they are exempted from the identification and verification requirements in respect of a business relationship or single transaction concerning any long-term insurance policy which provides benefits only on the death, disability, sickness, or injury of the life assured in the policy. So you do have a couple of exemptions, like accountable institutions are also exempt from the know your client requirements under certain circumstances. That's if a client is situated in another country, providing that the relevant anti-money laundering requirements in that country confirms in writing the identity of the client in question has been established and verified. Banks enjoy relief from many of the KYC requirements on condition that the client account meets certain restrictive conditions. All accounting institutions are required to have a money laundering officer, which is also referred to as a compliance officer, and should not be confused with the FACE compliance officer. The money laundering reporting officer has to investigate the transactions and will send the reports to the Financial Intelligence Center. There's a limited time to do this, and there's very stiff penalties if the requirements are not met. We stated the crime of money laundering consists of three essential elements. There has to be an act, there has to be proceeds of unlawful activities, and there has to be a state of mind. But it's not only criminals who launder the proceeds of crime, but any employee who processes a transaction which they knew or suspect or should have known the proceeds came from a criminal offence and should have suspected that the transaction must be reported as a suspicious transaction or unusual transaction and didn't do so. There are three stages of money laundering. The first is the placement, and the placement can be done for a number of ways. For example, cash could be packed in a suitcase and smuggled out the country, or you could use Smurfs to defeat reporting threshold laws and avoid suspicion, or other common methods include loan repayments on loans or credit cards with illegal proceeds, gambling, currency, smuggling, or using a legitimate cash-focused business to commingle dirty funds with the day's legitimate sales receipts. Layering is the next stage, and layering means that that stage becomes very complex and often entails the international movement of the funds, and then of course the integration stage where the money is returned to the criminal from what seems to be legitimate resources. So what would be an offence? Well, if you conceal the disguise, the nature, source, location, or disposition or movement, or conceal or disguise the ownership or any other interests that any person may have in those funds, or assist any criminal to remove or diminish the funds, or assist another to benefit from the funds, or assist another to acquire, possess, or use those funds, you have committed a crime. Let's have a look at possible money laundering offences. And these are when you apply for something like an application for a policy or savings account from a potential client in a distant place where a comparable policy could have provided the same benefits closer to home, or application for the business outside the normal policyholder's pattern of business, an introduction by an agent or intermediary in an unregulated or loosely regulated jurisdiction, such as where organized criminal activities or corruption are present, something like Zimbabwe, for instance, or where the client affects very unfavorable circumstances which are unrelated to the health or age. Those would all be suspicious transactions. In addition, if the applicant for the insurance business is reluctant to provide normal information when applying for the policy, or gives fictitious or minimal information, or the information that's difficult or expensive to verify, if there's a change of the designated beneficiaries, especially if this can be achieved without the knowledge or consent of the insurer, or the right of payment could be transferred by signing an endorsement on the policy. Substitution during the life of an insurance or an investment contract of the ultimate beneficiary with a person without any apparent connection with the policyholder, or the transaction involves the use and payment of a performance bond resulting in cross-border payment, the first premium being paid from a bank account outside the country, or insurance policies that have values that appear to be inconsistent with the client's needs. Those are also. When an applicant for insurance or investment business appears to have multiple policies or savings accounts with several institutions, or if the applicant for insurance or investment business purchases policies in amounts considered beyond the customer's apparent means. The insurance or investment policies are purchased with premiums that exceed the client's apparent needs, and the client requests an investment product that has no discernible purpose and is reluctant to divulge the reason for the investment. The applicant for insurance or investment business establishes a large insurance policy or investment policy within a short time period and cancels the policy, requests the return of the cash value payable to a third party. The applicant for insurance or investment business who wants to borrow the maximum cash value of a single premium policy soon after paying for the policy. These are all suspicious transactions and should be reported. You are considered to be willfully blind if you suspect the transaction involves the proceeds of crimes and you don't ask questions to either confirm or disprove your suspicion. And you are viewed then as having intentionally committed a money laundering offence if you do not report it. You are negligently ignorant if you do not apply common sense or general knowledge and skill and don't report suspicious transactions. You're considered to be negligently ignorant if you should have considered that transaction to be suspicious because of the training that you've received, and you would have been considered to have committed a money laundering offence. Always proceed with a suspicious transaction if you have one, just as long as you report it straight away. This way you have a defence that you reported the transaction and cannot be prosecuted. Tipping off is very, very frowned upon. Whether or not to terminate a business relationship is a commercial decision, except where it's required by legislation, for example, where you can't obtain the required client identification documentation. But when you decide to make a decision to terminate a relationship after you have made a disclosure or requested consent, and you are concerned that you may prejudice an investigation or contravene the tipping off rules, engage with the Financial Intelligence Center. It's a criminal offence if you know or suspect that an internal suspicion report to a money laundering reporting officer or a disclosure to the Financial Intelligence Center has been made or will be made, or if any other information on any other matter concerning the internal suspicion report or disclosure has been or will be communicated to a money laundering reporting officer or the Financial Intelligence Center, and you disclose this to any other person. That means that you have tipped off someone. It is clear from the legislation that we are very obliged, and from the fines, I think we can really say that word again, very obliged, that the onus or responsibility to identify our clients lies with us. You have to ensure the client is identified and that the identity is verified before entering into a business relationship or performing a single transaction with that person. And a business relationship is an arrangement between a client and institution for the purpose of concluding transactions on a single or regular basis. So if you have taken money once, or whether you are going to continue taking money, you will be considered to have the obligation to get to know that client and to keep and maintain those records of all transactions when conducting business relationships. Of course, banks can also get to know their clients through HANAS, which is the Department of the Interior or Department of Home Affairs. They have a fingerprint basis which they use for that. That makes it a lot easier. You have to decide whether you're dealing with the private customer or with the company. And if it is a private customer, you identify the private customer. If you're dealing with the company, you have to identify the company as required. And you have to also establish the potential risk rating. This is a new thing that's coming in with the Act, which is risk rating your clients and looking at them going forward. Now, risk rating will help you decide which category they fall under with regards to your client, your client identification, and that in turn is a guide to the documents and information you need from them to complete the client due diligence requirements, and you may have to go for enhanced due diligence at this. There are 3 stages of Know Your Client or client identification and verification, and those are identification, where you can use the harness, you can use an identity book, you can use a passport, must be a photographic identification. Your verification to make sure that they actually are the person they say they are, and that's normally done by addresses, and then profiling to see where they're going to sit within your business and whether you have to do enhanced due diligence on them. Profiling has to take place when a new account is opened. The profile should be used to monitor future account activity and entails the following: the source of the funds that will be used in the client's transactions, such as an inheritance or the proceeds of an investment, the source of income, which is different from the source of funds, and this could be a monthly salary or the income from the daily operations of a business, and the source of wealth for high investment amounts and high-risk clients. The type of activity that's expected on the account, which can be regular salary payments or cash deposits from the business. Records are of prime importance, and as we have seen, the fines for that has been around 10 million rand. So we don't want to be found short of our records. They must be kept of everything that was done with the client, and they should be filed in a customer file and kept for a period of at least 5 years from the date when the business relationship was terminated or from when the single transaction was concluded. This means all copies of the documentation, including but not limited to letters, application forms, offers to purchase quotes, receipts, emails, as well as further details mentioned, are to be kept. If you have an established relationship with your client, you should confirm his details in writing at least once every year and update records within 3 days of receiving a change of details and include proof. The records may be kept electronically or by a third party as long as the accountable institution has free access to it. And of course, keeping your records with a third party does not absolve you from the responsibility for those records. Availability of records is most important. Any authorized representative of the Financial Intelligence Center is entitled to have access to any of the records during ordinary working hours if they produce a warrant issued by a judicial officer authorizing such access. The money laundering reporting officer has to immediately comply with such a request. So it is important that if you ask for any of the KYC CIV documents, that you provide them without delay. In addition, we must make sure that we understand we have to keep those records safe from destruction. It is our responsibility, and outsourcing this to a third party does not absolve the financial services provider from keeping those records. Finally, we also discovered that we had to keep our records for 5 years from termination of the product or of the service that we were given to their client. We also know what we have to keep, and we are aware of the fact that failure to do this is an offence, and we could then get a fine of 100 million rand or 15 years in prison. I hope that you'll see me on the other side of Module 6 for enhanced due diligence, when ordinary due diligence is simply not enough. There is also an assessment for this course. Please do it to see if you have understood the material so far. Enhanced due diligence is required to be completed when the customer is identified as high risk through the screening process. And enhanced due diligence requires us to ensure that we understand all the possible risks associated with doing business with them. And the regulations require accountable institutions to establish a client profile for high-risk clients. You may hear people referring to such people as PEPs or politically exposed people. or persons. Simple identification and verification will not do with such high-profile individuals, and additional information must be obtained. Obtaining the additional information may request additional documents other than those listed, such as bank statements, vouchers, travel itineraries, and such. The additional information obtained must be adequate to reasonably enable the institution to determine whether transactions involving a client are consistent with the institution's knowledge of their client and the client's business activities, and they must include particulars concerning the source of the client's income or the source of funds the client expects to use in concluding the single transaction or the various transactions. You would have to appoint a suitable relationship manager to manage the affairs of those customers, and you'd have to obtain that additional documentation and information. You'd also have to make sure, if it's a business entity, that you know who is the ultimate beneficial ownership, and obtain the additional information and supporting documents relating to the customer's source of funds or source of income. For PEPs, you'd have to undertake a search of publicly available information relating to them, that's your sanction list, and obtain your senior management sign-off before approving the establishment of the business relationship or its continuation. Ensure your ongoing maintenance of customer information and monitoring the activity on the accounts would be mandatory. Who must report a transaction? Well, a person who carries on a business, a person who manages a business, or a person who's in charge of a business, or a person who's employed by a business, all must report. The suspicious transaction reports have no cash threshold, and the time for reporting is as soon as possible, but not later than 15 working days. You continue the transaction, and that's in Section 33, and the protection of the person making the report is in Section 38. In 2013-2014, the Financial Intelligence Center received more than 350,000 suspicious transaction reports, 6.7 million cash threshold reports on cash transactions of 25,000 or more, and 398 suspicious transaction reports between the 2014 and 2015 period. In terms of Section 28, these are the cash transactions, and they're presently set in the threshold level of 24,999 Rand and 99 cents per 24-hour period, and they must also be reported to the Financial Intelligence Center within 2 business days. Cash includes not only coin and paper money, but also traveler's checks, and the report must include the date and time of the transaction, or in the case of a series of transactions, the time of the transactions in the 24-hour period. Transfer of monies to or from the Republic on the instructions of a client, or receipt of monies on behalf of a client in excess of 3,000 Rand per day or 10,000 Rand per month must also be reported. So the report must say who were the transactors and the ultimate beneficial owners of the funds reported, what gave rise to the suspicion, and what was the time frame for the reported suspicious activity. In addition, where did the activity occur, how much has been reported, and what was the motivation for the reported activity. The Terrorism Act is reported on in terms of Section 28A of the FIC Act, and that's Pokdatara. And Pokdatara is quite serious because these entities are identified by notice issued by the President under Section 25 of Pokdatara, and you have to report that fact that this entity has tried to do a transaction and the prescribed particulars to the Financial Intelligence Center within 5 working days. And that, of course, will be done with your money laundering reporting officer. You cannot proceed any further with the transaction unless instructed to do so by the Financial Intelligence Center. If you have an inspection in terms of Section 45B, what do you expect? Well, the inspectors have a legal power to question managers and staff, order any person to produce a document, and access any computer system or equipment or examine, make copies or seize any documents. The inspector can also sample client files to ensure compliance with record keeping, client identification, verification, and reporting obligations. You can ask to see the certificate when conducting an inspection. They must have one. And any suspected criminal offence that has or has been suspected of being committed by the person who is the subject of the search, or if the premises are a private residence, the inspector may only conduct the inspection after the magistrate or judge has issued a warrant. So what would be your sanctions or your criminal sanctions? Well, for the following, that is the duty to identify and verify your client, your duty to keep records. Your reporting duties would be 50 million rand for a legal person and 10 million rand for the natural person in the administration sanction. The criminal sanction could be 100 million or 15 years imprisonment for either person. You have the duty to keep records. You have to identify and verify your clients. You have to formulate and implement internal rules if you have a FSP. You have reporting duties. You have training of employees regarding the Financial Intelligence Center Act and internal rules. You have to appoint a compliance officer if you are an FSP, and you have to register with the center if you're an FSP. If you don't, you have an administrative sanction that may apply to you, and that's 50 million rand for a legal person or 10 million rand for a natural person. Criminal sanction of 100 million or 15 years imprisonment would apply if you don't identify and verify clients, and you don't do your reporting duties for suspicious transactions, and you don't keep records. Failure to register with the Financial Intelligence Center or train your employees regarding the Financial Intelligence Center Act and requirements and internal rules, or to appoint a compliance officer or to formulate and implement those internal rules could result in a criminal sanction of 100 million rand or 15 years imprisonment. Non-compliance could also amount to a crime punishable with hefty fines if the Financial Intelligence Center refers matters to the South African Police Force and other authorities. The South African Police Force may investigate non-compliance with the Financial Intelligence Center on their own accord as well. There's a real risk of criminal prosecution in non-compliance matters. The number of such cases are already in the criminal courts, and the risk of criminal prosecution is real. Reporting is a defense against the charge of money laundering, and this is not only in terms of the Financial Intelligence Center Act, but also in terms of Section 7A of the Prevention of Organised Crime Act 121 of 1998. So reporting is a good idea. The Financial Intelligence Center will issue a notice of inspection where appropriate. That's Section 45B1 of the Act. The inspection normally starts with them sending a notice issued from a mailbox called inspections@fic.co.za, and the notice sets out the following: the name of the institution to be inspected, the date and time of the inspection, the purpose of the inspection, the possible consequences of the inspection, and the inspection contraventions in terms of the Financial Intelligence Center Act. You will also be told who needs to be present during the inspection and what documents to provide prior to the inspection. The inspection normally starts with completing a questionnaire, and then staff members are questioned to determine how they were trained on the FIC Act and the internal rules therefore, and their knowledge regarding the client identification and verification and reporting obligations. So your training must cover that. If you think compliance is expensive, please try non-compliance. And that is what the U.S. Deputy Attorney General Paul McNulty stated. And I think that is very true for us. Thank you for attending this course. We have reached the end. You may go to Naked Minds, just add education, to find out more about our courses. And we do hope that you will enroll in more of our compliance courses, which are meant to be affordable, easy to listen to, whether you're in a car or whether you are watching them on your computer, and help you to avoid making expensive compliance mistakes. Have a lovely day. Bye-bye.